You know, when you make a promise to someone, have you ever stopped and wondered, wait, is this legally a thing? Well, that's exactly what we're going to figure out. We're jumping right into the Indian Contract Act of 1872 to see how a simple promise can turn into a deal that the law will actually enforce.
So let's make this real. Imagine you casually tell a friend, yeah, sure, I'll sell you my old laptop. Is that just a friendly chat? Or have you just accidentally stepped into a legally binding situation? That's the core question we're tackling today.
All right, here's our roadmap. We're going to start with the huge difference between an agreement and a contract. Then we'll get into the building blocks, making an offer and then accepting it. After that, we'll look at all the essential ingredients that make a deal stick. And finally, we'll see what happens when it all falls apart.
Okay, first up, agreement versus contract. Now, you probably use these words interchangeably, right? I mean, I know I do. But in the eyes of the law, they are worlds apart. Let's get into it.
So, what even is an agreement? The official definition sounds a bit legally, but all it really means is a set of promises. It's a two-way street. I promise to do something for you, and in return, you promise to do something for me. That something in return is what the law calls consideration, and it's the absolute heart of any agreement. Think of it like a recipe. Seriously. Step 1, you start with an offer. Step 2, that offer gets an acceptance. That combination creates a promise. Then you add in that consideration we just talked about, that's something for something, and voila, you've just made an agreement.
But here's the thing, an agreement on its own might just be, well, an agreement. To level up, to become a real, actual contract, it needs one more crucial feature. It has to be enforceable by law.
And this right here, this is the golden rule for this whole topic. A contract is an agreement plus legal enforceability. That plus is the magic ingredient. It's the line in the sand between a casual promise you make to a friend and a serious deal a court will recognize.
So here's a good way to think about it. The word agreement is like this huge, wide open category. It includes everything from promising to meet a friend for dinner to a massive business deal. But contract? That's a much narrower term. It only refers to those agreements that have legal teeth, which leads us to a classic saying in law. All contracts are agreements, but, and this is the important part, not all agreements are contracts.
Okay, let's go back to our recipe and look at that very first building block. This is where it all begins, with the proposal, or as we all know it, the offer.
Now, offers aren't all the same. They come in all sorts of flavors. You've got your specific offers made to just one person, and you've got counter offers, which is basically when you say, nice offer, but how about this instead? But let's talk about one of the most interesting kinds, the general offer. To really wrap your head around a general offer, we've got to take a little trip back in time, to 1893 to be exact. And we have to talk about this amazing case, Carlyle versus the Carbolic Smoke Ball Company. It's a story about a very weird product and a very, very public promise. So, this company put out these newspaper ads for their product, the smoke ball, and they claimed it could prevent the flu. They were so confident, they made this wild promise. We will pay a 100-pound reward to anyone who gets sick with the flu after using our product correctly. This wasn't an offer to one person. It was an offer to literally anyone and everyone who saw the ad. Now, it's also really important to know the difference between a real offer and something called an invitation to offer. A real offer means you're ready to be locked in the moment someone says yes. But an invitation, well, that's just testing the waters. Think about a price tag in a shop. That's not the shop offering to sell you the item. No, it's them inviting you to make an offer to buy it at that price. See the difference? So, an offer is out there. What comes next? You need the other side of the equation. You need the handshake moment. This is what turns a one-way street into a two-way deal. Valid acceptance.
I absolutely love this quote from Sir William Anson. It's just perfect. An offer on its own is just sitting there, kind of like a train of gunpowder. It has potential, but it's not doing anything. But acceptance, that's the lighted match. The second it touches the offer, boom, you have an explosion. You have a binding promise, and you can't take it back.
But hold on, not just any yes is going to work. For an acceptance to be valid, it has to follow some strict rules. It has to be a mirror image of the offer. You can't change the terms. It has to be communicated clearly. And this last one, this one is huge. Silence is not acceptance.
You can't force a deal on someone just because they didn't say no. And this very rule was locked into place thanks to this classic case. I like to call it the case of the silent nephew. An uncle wanted to buy his nephew's horse, so he wrote him a letter and said, "If I don't hear from you, I'll just assume the horse is mine." Well, the nephew stayed quiet, but the courts said, nope, you can't do that. His silence didn't mean yes, so there was no deal.
Okay, so we've got our offer, we've got our acceptance, we have successfully created an agreement. Now we need to go back to our main formula and add those special ingredients that make it legally enforceable.
So Section 10 of the Act gives us a kind of checklist. For a contract to be valid, you need things like free consent. I mean, that makes sense, right? A deal you were forced into isn't really a deal. You also need competency, meaning the people involved have to be adults of sound mind. And, of course, the whole point of the deal has to be legal in the first place. There are a few other things too, but one that's super important is the intention. Both people have to intend for their agreement to be a serious legal thing. You know, promising a friend you'll meet up for coffee? That's not a contract because you don't intend for there to be legal consequences if you cancel. The deal also has to be clear, and it has to be something that's actually possible to do.
So, what happens when one of these essential ingredients is missing? What happens when the whole thing goes wrong? Well, that's when we get into the messy business of deals that are void, voidable, or even illegal.
Let's break this down simply. A void contract is basically dead in the water. It was never valid to begin with, or something happened that made it impossible to carry out. A voidable contract, though, is different. It's a valid contract, but one person has an escape hatch. They have the option to cancel it, usually because their consent wasn't free. They were tricked or pressured into it. So let's wrap up our recipe. You start with a clear offer and a perfect matching acceptance. Then you mix in those essential ingredients, free consent, legal purpose, all that good stuff. Put it all together, and you've created something really powerful, a legally enforceable contract.
And that brings us right back around to the beginning. Now that you know the recipe, just think about your daily life. Every time you click I agree on a website, every time you buy a bus ticket, even when you order food at a restaurant, how many of those little, informal agreements are actually real binding contracts? It kind of makes you think, doesn't it?